Our menu for today will be the last two articles of Title 2 of Book 2 of the Revised Penal Code. These are Article 132, Interruption of Religious Worship, and Article 133, Offending the Religious Feelings. They are subsumed under the subtitle Crimes Against Religious Worship. Article 132, Interruption of Religious Worship. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. Then we have Article 133, Offending the Religious Feelings. It states, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon anyone who, in a place devoted to religious worship or during the celebration of any religious ceremony, shall perform acts notoriously offensive to the feelings of the faithful. Now, since these two crimes are somewhat related to each other, kung sa Tagalog pa parang magpinsan lang, I think it would be better if we compare the elements of both crimes. So, on the left side, we have interruption of religious worship, and on the right side, we have the crime of offending the religious feelings. Now, in the crime of interruption of religious worship, the offender here is any public officer or employee, whereas in the crime of offending the religious feelings, the offender here can be any person. In interruption of religious worship, the religious ceremonies or manifestations of any religion are about to take place or are taking place at the time the offense is being committed. Whereas in the crime of offending the religious feelings, the acts complained of are performed either in a place devoted to religious worship or during the celebration of any religious ceremony. And in interruption of religious worship, the offender here prevents or disturbs the same. What do we mean by the offender prevents or disturbs the same? He prevents or disturbs the religious ceremonies or manifestations of any religion which are about to take place or are taking place. Whereas in the crime of offending the religious feelings, the acts complained of must be notoriously offensive to the feelings of the faithful. We will explain this in the next slide. Now, in the crime of interruption of religious worship, the crime becomes qualified if it shall have been committed with violence or threats. Qualified because it increases the penalty as provided for in the second paragraph of Article 132. The penalty becomes prison correctional medium and maximum. Whereas for simple interruption of religious worship, the penalty is only prison correctional minimum. When you say any public officer or employee as used in Article 132, it refers to all public officers and employees, not just to public officers vested with the authority to effect an arrest or to implement a search warrant. So, unlike the other felonies or crimes in Title 2, for the crime of interruption of religious worship, any public officer for that matter, like the mayor, the barangay captain, the member of a sanggunian, a prosecutor, may be or can be held liable under this particular crime. Because, as I said, the phrase any public officer or employee refers to all public officers or employees, not just to public officers vested with the authority to effect an arrest. Now, is there an instance where a private individual can commit this crime? The answer is yes. A private individual, as a rule, cannot commit this crime except when he conspires with the public officer concerned. Now, if there is no evidence of conspiracy, then the private individual may be held liable for unjust vexation under the second paragraph of Article 287. So, if it so happens that a private individual disturbs or prevents a religious ceremony or the manifestation of any religion, while he is not liable under this particular article, he may be liable for another crime, which is the crime of unjust vexation. But if he conspired with a public officer and there is evidence of conspiracy, then that is the only instance where he can be convicted for the crime of interruption of religious worship. Now, take note that in conspiracy, if two or more persons enter into a conspiracy, any act done by any of them pursuant to the agreement is in contemplation of law, the act of each of them, and they are jointly responsible therefore. This means that everything said or done by any of the conspirators in furtherance of the common purpose is deemed to have been said or done by each of them. This was decided in the case of People versus Go. The phrase religious ceremonies or manifestations of any religion. When you say religious ceremony, it is a ceremony having a religious meaning, or it is an established ceremony prescribed by a religion, or an act of public worship following prescribed rules. So, examples of religious ceremonies or manifestations of any religion are the performance rather of the seven sacraments in Roman Catholicism, like baptism, celebration of the Holy Eucharist or the Mass, sacrament of confirmation, sacrament of reconciliation, anointing of the sick, matrimony or marriage, and a priest's ordination. They are considered religious ceremonies. Now, I'm not familiar with the other ceremonies in other religions, but suffice it to say that with respect to Protestant churches, they have these so-called Sunday services. And of course, the rituals of other religious sects. They are subsumed or included within the term or phrase religious ceremonies or manifestations of any religion. In U.S. versus Balcorta, take note that in that case, the Supreme Court clarified that the law, I am referring to Article 132, does not require that a religious service must be conducted in approved orthodox style to be considered a religious ceremony. Because, in fact, in that case, U.S. versus Balcorta, the reading of Bible verses in a private house attended by a group of 10 or 20 persons from the Methodist Church was already considered a religious service. So, yung Bible study, no, parang Bible study, pwede yung i-consider as a religious ceremony. And if a public officer or employee disturbs or prevents the same, then he will be liable under this article, Article 132. In People versus Mejica, the barangay captain who threatened to kill the priest if he insisted on saying Mass, as a result of which the Mass was not celebrated, was held liable for this crime, the crime of interruption of religious worship. Do note, however, that it is immaterial if the offender actually succeeds in preventing or disturbing the same. So for as long as there is an overt physical act of preventing or an overt physical act of disturbing a religious ceremony or a manifestation of a religion, the crime is already committed or consummated. This is a crime of result similar to the crime of physical injuries. There is no attempted or frustrated stage. In People versus Reyes, it was held that the act of the chief of police in ordering his policemen to stop the minister of the INC and thereafter firing 2 shots in the air which dispersed the crowd was not a crime of interruption of religious worship but of Article 131. What is that Article 131? The crime of prohibition, interruption, and dissolution of peaceful meetings. Why? According to the Supreme Court, the act of the said minister in reading the Bible and attacking other religions at a public plaza, attended not just by members of the INC but people in general who were at the plaza at that time, was merely considered or is merely considered as a religious meeting, not a religious ceremony or a manifestation of a religion. That was the decision of the Supreme Court in People versus Reyes. So yes, no, the chief of police was still held criminally liable, but not under Article 132, but under Article 131, because the prayer rally or the religious meeting or the gathering rather of the INC was in that case merely considered a religious meeting, not a religious ceremony. Now, let's go to the crime of offending the religious feelings. For this crime, and unlike the crime of interruption of religious worship, the offender here can be any person, public officer or private individual. Now, what about the use of the phrase in a place devoted to religious worship? An example of a place devoted to religious worship are churches, temples, etc. Or any place for that matter as long as it is devoted to religious worship. Here, under this circumstance, it is immaterial that a religious ceremony is taking place when the offender performs acts notoriously offensive to the feelings of the faithful. So even if there was no religious ceremony taking place, but the offender commits an act that is notoriously offensive to the feelings of the faithful in the church, the crime is already committed. Situs, therefore, is very important with respect to this circumstance. But with respect to the phrase, during the celebration of any religious ceremony, situs is not important. But at the time, at the very time when the offender performs an act that is notoriously offensive to the feelings of the faithful, a religious ceremony must be taking place because the phrase states that it must be during the celebration of any religious ceremony. So here it is immaterial that the religious ceremony is taking place inside a church or a place of worship when the offender performs acts notoriously offensive to the feelings of the faithful. Now, how do we understand or how should we interpret the phrase acts which are notoriously offensive to the feelings of the faithful? The act of the offender here must be directed against religious practice or dogma or ritual for the purpose of ridicule like mocking or scoffing at or attempting to damage a religious object. So, how do we now compare the crime of offending the religious feelings from or with the crime of interruption of religious worship? In the crime of interruption of religious worship, the offender merely disturbs or prevents the holding of any religious ceremony. He does not ridicule, or attack religious dogma or practice. Whereas in the crime of offending the religious feelings, the criminal intent of the offender here is not necessarily to prevent or to disturb, but his criminal intent is to attack the religion's dogma, that particular religion's dogma, or its religious practice or ritual. He mocks or scoffs at or attempts to damage a religious object like the statues, no, in the Catholic Church. That is the big difference between the crime of offending the religious feelings and the crime of interruption of religious worship. In the case of People versus Gesulga, the Supreme Court stressed that there must be proof that the accused deliberately intended to hurt the feelings of the faithful before he can be held liable under Article 133, offending the religious feelings. What happened in that case? There was a religious procession, a Catholic procession, and this religious procession passed by the house of the accused. At that time, the accused was preaching, attacking, or mocking the Pope, and the Pope was is the head of the Catholic Church. He was attacking the dogma of the Catholic Church. And it so happened at that time, there was a religious procession that passed by his house. And for that reason, he was charged in court for the crime of offending the religious feelings. But the Supreme Court eventually acquitted the accused because according to the Supreme Court, there was no evidence that the accused purposely changed the topic of his preaching in order to attack the Pope, or that he would not have attacked the Pope if the Catholic procession had not passed by. Yes, his preaching, his attack against the Catholic dogma had hurt the feelings of the Catholic faithful. But even if it hurt the feelings of the Catholic faithful, there was no criminal intent on the part of the accused to deliberately hurt the feelings of the Catholic faithful. That was the point there of the Supreme Court in acquitting the accused. On the other hand, in People versus Reyes, the Supreme Court likewise acquitted the accused who, at that time when there was a pabasa taking place in a chapel, he was constructing a fence in front of a chapel or in front of the chapel, and it irritated or vexated those present during the pabasa, and for which reason he was charged in court, and eventually it reached all the way to the Supreme Court. But the Supreme Court eventually acquitted him because according to the Supreme Court, even if it irritated or vexated those present during the pabasa, it cannot be considered as notoriously offensive to come under the crime of offending the religious feelings in Article 132. In the case of People versus Baes, the Supreme Court pointed out that whether or not the act complained of is offensive to the religious feelings of the Catholics is a question of fact which must be judged only according to the feelings of the Catholics and not those of other faithful ones. For it is possible that certain acts may offend the feelings of those who profess a certain religion, while not otherwise offensive to the feelings of those professing another faith. So the point here is that the offense to feelings, for purposes of this crime, should be judged from the complainant's point of view, not from the accused's point of view. So even if the accused claims or maintains that his actions and utterances did not mock, ridicule, or attack religious dogma or the practice of any religion is not controlling for purposes of assessing or evaluating whether the crime has been committed. What should be controlling is the feelings of the person whose religion is being attacked. That is the point there in the case of people versus baes. So that ends our discussion on crimes against religious worship.